Good morning, everybody. This is Sarah Frame from Mass TLC. Welcome to this just really important topic that I know probably impacts each and every one of you on the phone. In July, the European Union ruled that the privacy shield is insufficient, leaving any company that transfers data between the US and EU in peril. Just last week, the EU provided some guidelines to help companies adhere to this ruling. But most companies are at the beginning stages of understanding the true impact it will have. We are extremely lucky to have three individuals with us today to share their expertise on this issue from a legal and technological standpoint. Before we get started, I want to thank IDA Ireland for sponsoring this program, and our security community sponsors, Nuance, Sonatype, and Vectra, for supporting the programs and initiatives within our security community, as well as our global sponsors who support us in everything we do throughout the year. It's now my pleasure to turn this over to our moderator, Aimee Williams, Vice President of Content, Consumer and Business Services Division at IDA Ireland.
Thank you, Sarah, and good morning, everybody, or good afternoon from Dublin. As Sarah said, my name's Aimee Williams, and I represent the Irish Government's Foreign Direct Investment Agency, IDA Ireland, where our focus really is on selling Ireland to multinationals to establish their international operations and then to provide ongoing support to them throughout their lifetime of having a presence in Ireland. We also act as a conduit between our client companies and government on key areas of policy for business. So as Sarah mentioned, at present, I specifically work across our digital technology, content, media and publishing, consumer and business services sectors. So our team works with all the large platform companies, including Google, Facebook, Amazon, Twitter, LinkedIn, as well as a broad mix of data and SaaS-driven technology companies, such as Dun & Bradstreet, Shutterstock, HubSpot, Accenture, and just to name a few. And collectively, these companies would employ tens of thousands of people here in Ireland. And in recent years, we really have seen the conversation increase with our clients around regulation and business environment policies. And this really includes discussing, well, what does the data protection landscape look like in Ireland? How does Ireland stack up for these functions? As an agency, we have a client portfolio of 1,500 multinationals running and servicing international business. And you may be aware that a number of these companies, including some that I have just mentioned, actually have their European HQ for data operations in Ireland, fall under the jurisdiction of the Irish Data Protection Authority. So I guess it's fair to say that we understand the importance of data protection and regulation for international business, and then the key elements of the environment in which they operate. So it's kind of why we're delighted to be here and partnering with Mass TLC on today's event. An interesting fact to note that maybe some of you don't realize that many of the first European data centers for companies such as Microsoft, Google, and Amazon were actually established in Ireland. And what's kind of interesting is what we saw happen on the back of that was the following of functions and activities around data protection and privacy. And this kind of started to build up a really experienced skill base in the sector that was supported simultaneously by the development of a very strong regulatory ecosystem. And I guess this has really stood up as, and stood out as a key attractor for companies in selecting Ireland for their main establishment in Europe, and also highlights kind of and points to the strengths of the Irish Data Protection Commissioner, who would be very well regarded and be seen as a strong, independent and competent authority by its counterparts in Europe. So great to be here today, have such a stellar panel, as Sarah said, who are really expertly versed in data legislation and highly experienced when it comes kind of today's subject matter. So delighted to have Gerald, Chief Information Security Officer from LogMeIn, Chris Hart, who is the partner and co-chair of the Data Privacy Data Security Practice at Hoag, and Aoife Sexton, who is the Chief Privacy Officer and Chief Product Innovation Officer at Trūata. And if for some of you who don't know, it's actually an Irish-based but joint IBM and MasterCard founded company that specializes in privacy enhancing technologies. So you're all very welcome, and thank you for joining us today. We're going to kind of set up the discussion in kind of almost three parts. So we're going to have a look at the context and background setting, bringing us up to today, what activities people are kind of concerned about and looking at, and then a bit of a look to the future. So with that in mind, I might ask Chris if you would maybe kick off and talk us through kind of at high level the European GDPR data regime, why it's important to companies, and bring us up to some of the background.
Right. Thanks, Aimee, and it's great to share this panel with you, Aoife and Gerald, and to be talking to you folks who are listening to this webinar. So, from a table setting perspective, what's the GDPR? What does it do? If you're listening to this webinar, you already have some sense of it, but because I talk to a lot of U.S. clients who still are curious about whether they need to comply, when often the answer is yes. Just a little bit of background. So the General Data Protection Regulation for the European Union, or the GDPR, is a comprehensive set of rules, laws, regulations around the processing and transfer and enforcement of privacy rights of European residents, and not just of the European Union, but of the European Economic Area. What it does is it defines personal data very, very broadly. So if you're used to US privacy law outside of heavily regulated industries, you're used to privacy being defined very narrowly. That is, personal information is your name plus something that can lead to identity theft, like a social security number or something like that. And if that gets breached, then you have certain obligations that flow from that. The GDPR defines personal data very, very broadly. It's basically anything that can identify you. And it sets restrictions and requirements around how it is lawful to process that information. It processes use, storage, transmission, analysis, anything that you do with the data. And if you're not otherwise very familiar with the GDPR, you might be familiar with things like the right to erasure, or the right to delete information. There are affirmative rights that the GDPR provides for individuals that all are grounded in the European Union's view of privacy as a fundamental human right, as opposed to, say, a balance between consumer and business interests, which is normally what you see in the United States. That's very general table setting. One of the most complex and difficult areas, especially for U.S. companies to deal with, is this question of data transfer, which is the topic of our conversation today. And the reason it's complicated is that the way that U.S. companies tend to think about the GDPR is that it restricts transfer, which is true. It restricts transfer, it puts a lot of restrictions over what can be transferred out of the EU to other countries, and particularly the US. But it's also fundamentally a regime that allows for transfer within the European Union. That is, it's meant to make it easier to transfer within the EU, because every member state has the same law and same set of protections. And so what the GDPR does is it creates a set of rules around, if you're transferring personal data outside of the EU, you have to make sure that it has the same level of protection that you would get within the EU. And you can do that in a number of ways. The best way is if the European Commission has a determination that the jurisdiction outside of the EU has an adequate level of protection. The US is not determined to have an adequate level of protection. And so there are lots of ways around this. One that you're almost certainly familiar with was the Privacy Shield. And I won't get into a lot of history on the Privacy Shield, except to say that, in particular, I think what Aoife is going to talk about is a we've been here before kind of thing, which is that the Court of Justice determined that a previous regime where data transfers were allowed to the United States wasn't adequate. The Privacy Shield was negotiated between the EU and the US as a way to self-certify, and for companies to self-certify and allow for data transfers for companies that self-certified and made all sorts of promises around transfer. Outside of Privacy Shield, for companies that have not been Privacy Shield certified, or now for any company, there are a couple of other mechanisms. One is a set of model clauses, standard contractual clauses that predate the GDPR, that were grandfathered in and that are now subject to revision. There's the potential for binding corporate rules, which are rarely used, but they can potentially be used as a mechanism for data transfer. And then there's a whole set of what are called derogations, which is individual consent to transfer or other legitimate interests or potential use of contract, which have to be used very sparingly, according to the GDPR as well as through guidance. So that's essentially the complex array of law that makes it difficult to find ways to get European resident personal data over to the US. You have to follow one of these mechanisms in order to, the way I think about it is that it's like putting your data in a box. You can't just put it in the box. You got to bubble wrap it. And the question is, how do you bubble wrap the data? And it used to be that you could do it through Privacy Shield. Now you can't. And the question is there anything left? And that's what we're talking about today, is what's left, and how can we limit liability and think realistically and practically about how to effectuate data transfers from the EU to the US.
Thanks, Chris. And I think it just might be interesting to just bring Gerald in here and kind of just understanding the context of how did LogMeIn navigate around the GDPR, to share some insights there, and then we can move into some of the ruling aspects.
Yeah, sure, absolutely. Thank you for having me on the panel. I think this is a great initiative, and even though it feels to me that I've been talking the last 2 years about a few other things as often as the GDPR, I think, as you said in the beginning, it is a super important topic for companies around the world, really, because the way it's constructed, it really affects all of us in some form or another. What we did at LogMeIn is we started out really late 2016, early 2017, so it's way before the regulation got into force. And it was a journey. It was definitely not something that we took lightly or were able to do overnight. It was important to us to really truly understand and stay on top of some of the legal interpretations of the GDPR, and then put those kind of obligations into actionable controls inside the company, and then move forward. And that took quite a while. It's not easy to really look at the entirety of a fairly large operation as LogMeIn. We have about $1.2 billion worth of revenue. We have over 4,000 employees. We have literally millions of customers worldwide, and millions in Europe. So it's looking at the vastness of the problems. It was very clear to us that this was quite a journey that would not be finished on May 25th. 2018, even though we had to be ready for that day. Some of the key elements in our strategy in terms of moving forward was definitely that we wanted to make sure that we would be able to fully understand the data flows and also the type of data that really was coming into our systems. I remember at the beginning we were really looking at the possibility what kind of data is really covered by GDPR, what data should be covered by the GDPR, how should it be covered. What about accounting data? It's so the information you find on invoices. How do we treat that with regards to additional rights? And it's really going through the motions of fully understanding and classifying this data. It's understanding what kind of overriding business requirements we may have in order to keep it despite the deletion requests. Was definitely a huge challenge that was that we really needed to go through. So from that perspective, it was quite important across the board to have this consolidated program that really covered the entirety of the organization. From a security team's perspective, we were extremely closely aligned with the legal team for obvious reasons, and really made sure that we looked at the obligation from a regulatory and legal perspective, and then translated that, like I said before, into actionable privacy controls that could eventually be audited and then maintained over a period of time. Once the May 25th came, it's we had a GDPR birthday party with a cake and everything else. It was kind of fun. just to make sure that people actually paid attention to it, which was important because even at that time, and even though we had done a lot of outreach internally inside the company towards the product teams, towards the sales teams, the marketing teams, et cetera, it was still a little bit of an uphill battle to make sure that everybody took this into their consideration moving forward. Because if you have, say, for the marketing teams that are potentially collecting a lot of information about customers or potential customers, it is really important that they fully understand that certain aspects of their activities, whether it's the collection or the processing of data, really need to be done in a way that is consistent with the purpose for which they were collected. And driving that awareness throughout the company is actually, I would say, one of the biggest ongoing challenges or tasks that we have. It never ends because you always have new employees joining the company, people changing positions internally where they did not necessarily have quite as much obligations to pay as close attention to. So I think it is this driving of awareness is really something that is critically important. And needs to be maintained on an ongoing basis, because if you don't, then you end up being in situations where you inadvertently end up doing things that are potentially not consistent and need to be remediated, sometimes in painful ways. The other thing we obviously did after the 25th was to monitor the ongoing interpretation and case law, fines, etc., with regards to like what this whole thing really meant. Because I'm not sure how this panel feels about it. For me and for some of us, it really felt like, okay, we have this great piece of legislative regulatory art in front of us, but what does that really mean? I mean, it's like for real. So how do you break this into practice? And I feel that is something that really took a while for us to get right, and still to this day continues to get right. The Schrems II decision is one classic example of like where we're looking at relying partially for certain types of transfers on Privacy Shield, obviously using other things like the standard contractual clauses as well. But it's like it definitely required us to revisit some of the assumptions we had, and then make sure that we can adjust any kind of DPA, any privacy policies. The initial Schrems II decision.
Yeah, so
Sorry?
you go through a huge amount of work to get prepared. Can you, is that you okay there? Come in, and then, you know, it's an evolving piece of legislation, which I think has come forward, particularly in light of some of the rulings of late, and one being the kind of the Court of Justice of the European Union's ruling from last July. Might bring Aoife in here, and maybe you might share some insight on that and the impact of the decision there on the Privacy Shield, and it's some of those impacts of doubts that were cast, kind of as Gerald was alluding to, kind of the challenges around that.
Yeah, hi everyone, and thank you very much for having me on the webinar today. I think Chris did a super job at explaining, you know, the overall transfer mechanisms and why we actually do have the transfer mechanisms, and it's quite logical in many ways. If you're going to have a law protecting the rights of individuals in Europe, you can't suddenly have those rights fall away from the moment in this current interconnected digital world as soon as you press a button and the data leaves the European Union and suddenly the rights of the citizens are no more. So it makes sense that, you know, the law applies, and there are responsibilities, particularly on the data controllers, when they want to take European citizens' data and export it and to send it to other companies around the world in particular. So yeah, I mean, Chris mentioned there is a sense of, well, we've been here before, and you know, the transfer mechanisms that had been used for the US before was the safe harbor. And you know, it was a particular Austrian law student called Max Schrems, particularly relating to Facebook, who wondered whether or not Facebook, in transferring data from Ireland to the US, whether or not that really was, whether there was enough protection there for European citizens' data. And he took a complaint to the Data Protection Commission in Ireland and a case to the High Court, and that led to the Court of Justice back in 2015 deciding to strike down the safe harbour. And the main reason at the time was really to do with law enforcement agencies in the US and their ability to access non-US citizens' data, and the lack of rights for European citizens, and in particular the lack of their ability to exercise their rights in the US. And that was really the main reason why the safe harbor was struck down. So Max Schrems then took a look at the standard contractual clauses and felt, well, if the reason for the ruling of the court at the time was to do with the US agencies, surveillance agencies, and therefore not having enough protection for EU citizens' data, he felt logically that the standard contractual clauses didn't do a better job in that respect. So again, he went back to the DPC in Ireland, and the DPC in Ireland referred a case to the Irish High Court. And it was interesting, as part of Judge Caroline Costello's decision, she decided to refer the case to the European Court because it had it related to matters of EU law. And it was at that time she did have a number of questions about standard contractual clauses, but also she kind of molded in Privacy Shield at the time. So when the Court of Justice came out with its ruling in July, there were two areas of its decision that were of importance. The first one was the Privacy Shield, and as Chris mentioned, the Privacy Shield essentially replaced the safe harbor. And the court felt that, in fact, the US agency surveillance rules, again, didn't provide adequate protection for EU citizens, and it declared it invalid. So it was pretty stark, and any US companies or EU companies that were relying on US companies to have self-certified on the Privacy Shield from the date of the judgment, they no longer could rely on that as their transfer mechanism because it was declared invalid. So therefore, the court moved on then to look at standard contractual clauses. Now, what the court said with regard to standard contractual clauses, it wasn't as stark as with Privacy Shield. It did not declare them invalid. But what it did say was that if an EU exporter was going to rely on standard contractual clauses as their transfer mechanism to lawfully transfer to the US, it would have to assess on a case-by-case basis, taking into account the relevant aspects of the legal system of where you were sending the data to, and you would have to look at whether or not you essentially were guaranteeing equivalence to the protection given in the EU. And if you weren't, and if there were gaps, you were to look to try and fill the gaps with what we call supplementary measures. Now, the court didn't go on to state what would constitute a supplementary measure such that it would be sufficient, such that you would achieve this essential equivalence. And therein, it kind of left that hanging. So when practitioners were reading the decision of the court, that was one big question mark thereafter. Very quickly, when the court decision came out, the European Data Protection Board, which is a board that is made up of the supervisory authorities in Europe, came together and issued an FAQ giving some guidance on how companies should read the court decision, i.e. they should understand that Privacy Shield is invalid and you can no longer rely on it, and therefore you need to look for alternative transfer mechanisms if you had been relying on Privacy Shield. And if you were to turn to look and rely on standard contractual clauses, you would have to do a sort of a transfer impact assessment. And they did say at the time that they were going to come back and give guidance and recommendations on what might constitute these so-called supplementary measures, which might, fill this gap between, a standard contractual clause, the law of the country into which you're exporting to, and then some additional measures that would then supplement. All in all, holistically, then, when you bring it all together, the cumulative effect would be you would achieve essential equivalence, which would allow you to transfer data. The purpose of this call is to talk about transfers to the US, but it is important to note that the court's decision is wider in its ambit. Obviously, when it reviewed the transfers and the complaint, it was related to transfers Facebook to Ireland to Facebook US, but the decision has global impact, meaning that if you are an exporter in the EU and you want to transfer data out to a non-EEA country, and if there's no adequacy decision for the country in which you're sending the data, you will also have to do a transfer impact assessment, which means you have to look at the law of the country to which you're exporting to decide if there's essentially enough there to give equivalence. So it applies to the US, and in fact the US is under the microscope because you know, the DPC in Ireland followed up fairly quickly and issued an order to Facebook that it wouldn't be using standard contractual clauses for transfers to the US, but that's under review at the moment. But it does apply globally where you're transferring data outside the EEA.
Thanks, Aoife. I think that's a really comprehensive review. I mean, Chris, from this ruling, what kind of uncertainties do you see coming up with your client base, or what are the questions kind of in relation to the data transfers in light of this ruling?
Everything feels uncertain. I mean, what's interesting to me, Aoife, that was a really, really helpful overview of the current legal landscape. And one of the things that I've been commenting to clients is that right now it just feels like drinking from a fire hose. There's so much information coming out of the EU around, not just around transfers, but around a whole host of other issues. But transfers are really the hot button issue. And so in some ways, you know, all companies want to do, all US companies want to do is business. They want to do their business in the EU. And so the question is, how can we do business without completely upending the structure of the company? You know, the questions that I get are around, okay, so I'm Privacy Shield, I was Privacy Shield certified. What do I have to do with that now? Well, unfortunately, you still have to keep your obligations on the Privacy Shield because you've made a commitment based on the US Department of Commerce review of your policies and procedures that you're going to be under the jurisdiction of the Federal Trade Commission up until your certification lapses. The FTC and the US Department of Commerce have made clear that they're going to hold companies to their obligations, even though the Privacy Shield's purpose is completely undone. So there's that issue. But then there's the issue of, well, now what do we do if you're one of the 5,000 plus companies that's been relying on the Privacy Shield and you haven't had standard contractual clauses as a backup, do we now implement those? Well, as Aoife noted, sure, but the logic of the Schrems 2 decision implicates standard contractual clauses as well. And while there's now been some guidance over the kinds of technical measures that you can take to maybe split up your data, put it in a third country, use all sorts of technical measures, that's an enormous amount of work for companies to actually put together. You know, where are they going to place their servers? How are they going to then encrypt data? How are they going to segregate data? What organizations are they going to use to process certain kinds of sensitive data versus other kinds of data? That's a lot of work. So my advice as a practical matter has been the following. You know, as Aoife suggested, you have to do an assessment of what your data flow looks like, and this is something you should be doing anyway to become GDPR compliant. You would have had to have done this anyway. So that in a sense isn't new, but then there's a certain risk analysis that comes just as a practical matter for businesses, right? Not every business is a large global platform with, you know, 1 billion customers. And so they're not necessarily the ones with targets on their back. And I mean, I'm the lawyer in Boston, I'm not in Europe, but I don't really get the sense that the data protection authorities from various European countries are really keen to shut down business, which is really what we'll be talking about if we strictly enforced the letter and spirit of the CJU's decision. So a lot of this is a question of, as a practical matter, you know, what can you do to put yourself in good faith compliance? What kind of practical measures can you take to alter how you process certain kinds of data, to keep data in the EU when you can, and to try to secure as much as possible the transfer that you have, and make sure that you use standard contractual clauses, consent where it's possible to do so and where it's sensible to do so. But even now with standard contractual clauses, because there's a new draft and because it's possible that there will be revisions, there's some question about how you prepare for the implications of the new clauses. So I'm not really giving a lot of very good and hopeful practical advice, but what I can say is that this is, like anything else, a risk management question, and that each company's got to think very carefully about where its risks are, understanding that it's better to put itself in a place of good faith compliance, even if you can't alter U.S. surveillance laws, which is really what this is all about, and to try to structure the data flow in such a way that is not only practically feasible, but also that minimizes the amount of data that's being processed in the U.S.
I just generally agree with you, Chris. It's like I would make some annotations to that. It's like I think some of the things that we've seen recently is like both from country level regulators as well as at the European level, is that they have expressed very clear ideas about the type of technical controls they would foresee, which are required in order to make the SEC, the standard contractual clauses, whole again, and be adequate for an adequate kind of a mechanism for data transfers. One of the things that is particularly pertinent for us at this time is the use of end-to-end encryption. I mean, that's something that's been in the collaboration space being discussed for, well, it's like if we go into more security-related tools like Signal, for literally almost a decade, and if not longer. But it's like at the same time, it is now really something that has become very pertinent across the larger industry. I think looking at what those specific kind of controls and mechanisms are that the regulators are contemplating as appropriate kind of measures is really important for everyone who's putting this into practice. And not only from building it there on their own, it's like we're in the lucky position that we can start to think about how we want to put end-to-end encryption into our products, but also into how it makes sense to really look at vendors who are providing services to you as a company, whether it's in the customer relationship management space, whether it's in collaboration space such as ours, or anything else, and see in how far certain types of technical controls are supportive of making sure that you stay within the framework that that the EU has put forth so far. So, and what we have seen, or what I've seen, at least looking at some of the opinions, they're actually quite straightforward about that. It's like they're not holding back and saying, it's like, yeah, try your best, and it's like here's some brownie points for attempting to play. They're really clear that this is a requirement that they intend to enforce down the road. Maybe not necessarily small companies that only have like a very limited amount of data to be transferred, but definitely down the road, this is going to be something that is important to the regulators, at least as far as we can see. So as far from the risk management perspective, if I look at this, it's like I treat this as a fairly high risk to our business operations there and our product roadmaps in order to make sure that we are meeting those kind of requirements. And that is very challenging in some parts, because we're looking at a lot of technologies that are have been around for a while, and just adding on, quote unquote, end-to-end encryption calling a day is a lot harder than it may seem in the beginning.
Yeah, Aimee, I might come in and just add on, if that's okay, just on, since we've moved on to the recommendations that the European Data Protection Board came out with. These were dated on the 10th of November, and essentially these recommendations, as I said, were long awaited because people were wondering, what are these supplementary measures that were referred to in the Court of Justice's decision? What might they be? Could the regulators give us some guidance? Because maybe this is the silver bullet that we all need. And you know, in reading them, I think most people come away and go, no, they're not a silver bullet, but they may be useful in certain instances. And Gerald has alluded to one, which is end-to-end encryption. A couple of comments, I suppose, on the recommendations, because they're very detailed. I think I would agree with Gerald that the way the supervisory authority and the European Data Protection Board seem to be indicating that this isn't a risk-based assessment. They are saying you must demonstrate equivalence. It's the essential equivalence, which is a really high threshold. And actually the GDPR has been based around risk-based assessment. And in some ways, they almost are moving away from that in this recommendation. They very much are stressing accountability, the principle of accountability, and documenting and proving that what you are doing is enough for you to feel that it's a lawful transfer. And the responsibility heavily weighs on the controller in ensuring that they've done enough. And they outline, I mean, they do give some practical guidance in that they outline 6 sort of steps that you should do. The first one, of course, starts with knowing your transfers and knowing what it exactly, you have, where is it going. But, even that's tricky, because trying to figure out onward transfers isn't an easy thing. And it can be a very big jigsaw, and even companies will struggle to understand their sub-processors and their sub-processors. And there's quite a chain there, and trying to figure out all the countries where that data could land is complex in and of itself. And then once you've identified your transfers and where they're going, you need to know which of the various mechanisms you're relying on. Is it adequacy, or is it standard contractual clauses, or binding corporate rules, for example? And then, for me, the trickiest bit is step 3, which requires you to look at the laws of the country into which you're transferring the data. And really, this requires you to look at, is there essential equivalence there? So you're trying to assess surveillance laws. And typically, that's not something privacy pros would do on a day-to-day basis, and trying to even understand what those laws might be. And there is a second publication of a document which was done on the same day as the recommendations around guarantees, and it's a companion document that you'd have to review when you're reviewing the laws of the country. But that is tricky, it requires a certain expertise that is a rare expertise around surveillance laws, and trying to figure out whether or not the SCCs in and of themselves will conflict with what's actually happening on the ground. And then where you figure that there are gaps in the level of protection, having read the laws and understood them, you then look at whether or not you can fill those gaps with supplementary measures. And these fall into 3 categories: technical, contractual, and organizational. The EDP says that only the technical in and of itself can fill the gap, and that if you're going to rely on contractual or organizational measures, they by themselves won't be sufficient. And then in terms of the technical measures, they talk primarily about end-to-end encryption, so for example, that would be where you from Europe have sent data perhaps to a cloud provider, and it's encrypted both in transit and at rest, and it's there for backup maybe, or storage purposes. But what it says is typically you wouldn't need to access it, what we call in the clear, meaning you don't need to decrypt it and use it for something. So it's encrypted end to end, but also at rest. Then talks about pseudonymization, and it talks about the type of pseudonymization that you'd need to look at. And it talks about both pseudonymizing direct and indirect identifiers, and whether you've achieved enough on a threshold of pseudonymization will hinge on identifiability. The idea is that you do enough to the data such that in transit or at rest, even if a government authority asked to access it, they couldn't identify the person whose data is attributed to them. So you have to do enough. It's not light touch pseudonymization. And you also have to take into account the type of information that could be available to a government agency such that they could kind of re-identify from a pseudonymized data set. So it's a high enough threshold, but it is doable. And then they also talked about split or multi-party processing, where essentially it's like a jigsaw piece. You send certain parts of the puzzle to different processors, but no one processor in and of themselves has enough information to identify. They also came up with 2 examples where they felt there were no technical measures today that would suffice, such as to allow the transfer. And unfortunately, most people have focused on those and saying, well, actually, they're in the main part what would be a typical SaaS offering or IaaS offering, whereby you need to see the data in the clear, meaning you have to do something with the data such that you need to know it's data relating to Aoife, and where pseudonymization may not be enough. And they said that right now they're not aware of technical measures that would be sufficient such that that data could be sent. And I think a lot of people have looked at that and wondered, what does this really mean for SaaS models where data is being exported from the EU to the US? So we're a company that actually is privacy enhancing technology company. So we focus on pseudonymization and anonymization. And in both instances, if you anonymize the data, it falls outside the Gdpr, so you can send it. It's not even a restricted transfer. In the case of pseudonymization, we would be working on technology such that you can risk assess your data and understand within any data set how much direct and indirect identifiers you have, and then give you these dials where you know where you need to focus on the columns of big data to ensure that you've adequately and sufficiently pseudonymized the data. So it's companies like ours that are trying to come up with some solutions, and we're even working on some solutions for use case 5 and 6, which is about data in the clear, trying to come up with solutions where the data remains in Europe, but we create a level of abstraction such that an analyst can't see the data, but they could query the data, and then they extract aggregated anonymized data from having queried the data or created machine learning and model codes from the data. So, you know, there are technological solutions being worked on, and some are available on the market and some will be coming to the market soon, but we'll need a pragmatic approach to the adoption of these as well. And that's not to say, as Gerald and Chris both said, it's a lot of work for companies to look right down at the data layers within their organization. This isn't paperwork. This isn't your privacy policy. This isn't a quick fix. This requires a review of your work processes, your data processes, and investment in technology in order to future-proof where you're going with your data. But probably that's the direction of travel of data protection at the moment, because you've got all these false kind of dawns, like you're climbing the mountain, and you know, you get to the top of one hill and then you realize, you know, you've got to do something, and it all comes down to really getting down at an operational and organizational level to personal data within your organization. And no tick box exercise is going to get you past really operationalizing privacy and having a program that works in that way.
Yeah, I think technology is going to be a key part of this. And, you know, you have a lot of the companies who now the conversation is talking about data by design, and to Gerald's point of kind of building products and solutions with data in mind. Just conscious of time, I just want to check in with Sarah if there's kind of any questions or points of clarification on any kind of matters at this point in time.
There are no questions, but I do urge any of our attendees to please, you know, put them into the questions box. If we can hold them to the end, but just so you don't forget them. I know this is very complex, so please, this is why our great panel is here. So don't be shy.
I take the lack of questions
Thanks,
as being showing just how clear we are in talking about that.
Yeah, mind if I throw some a small little wrench into this? It's like, I think one of the interesting developments that we've seen over the last few years was this resurgence of the crypto wars. It's like the crypto wars 2.0, as it's been sometimes termed. We had in the early 90s a strong desire by various agencies, law enforcement around the world, to weaken cryptography so that they can still tap into this. The Clipper chip in the US, I think, was the most well-known example of a failed attempt on how to do this. And I think this is resurging again right now. One of the things that was interesting, particularly in the context of the GDPR, is that just a few days ago, apparently a document surfaced where there is a desire from various parts within the EU administration to really put a tap on encryption capabilities and make sure that there are lawful access backdoors into encryption. Combining that with the idea of end-to-end encryption or zero knowledge encryption at rest obviously poses a huge challenge. So I think one of the big debates we're going to be having in 2021, 2022, at least as far as I'm expecting it, is to see this kind of discrepancy or this kind of diverging interest between law enforcement and surveillance agencies on the one side, and privacy and data privacy or data protection authorities on the other side. And what I find extremely frustrating as a commercial company is that we're essentially in the middle of this. It's like, and this is not even US and EU. It's like US saying we want to tap, and it's like EU says no, you can't. This is literally EU versus EU. So I'm hoping that going forward that there's a clarity, an increased clarity about what they actually want, because you cannot have both. You cannot have end-to-end encryption and backdoors, or if you do, then why have end-to-end encryption in the first place? Any thoughts from either one of you, Aoife, Chris?
Well, that's very interesting. I hadn't thought about that, and what you made me wonder was, Aoife talked a lot about the recent EDPB guidance that we got. That's very comprehensive, and I think we could talk about that all day. But one of the things that comes to mind, just in terms of the EU versus EU, is to what extent we're going to see divergence, or we can anticipate seeing divergence among different data protection authorities and how they enforce compliance or non-compliance with regard to transfer. I mean, the guidelines are guidelines, right? They don't have the force of law. And while DPAs have been largely deferential to the EDPB, especially in light of Schrems 2, issuing statements that fall in line, say the right things about the CJEU decision and saying they're adopting the EDPB guidelines, in practice, the EDPB tends to be fairly conservative. And it strikes me that it can be difficult to enforce sort of in the day-to-day, and it really depends on which DPA we're talking about, and that has real implications, because if you're an entity within the EU, that's one thing. If you're in the US and you do business primarily in France or in Ireland or in Germany, it's going to have different implications for how you assess your risks. And I suppose we could look back at past DPA actions over the past 2 years and just see how enforcement has differed. But some of this is political, and some of it is who's got the biggest target on their back. So that's it's not a direct answer to your question, Gerald, but it does strike me that we shouldn't lose sight of the fact that there could be a divergence in enforcement that we really won't be able to that can impact how companies act, that we probably can't draw any conclusions from for a little while.
Yeah, no, I would
think
agree.
that brings up
Sorry, Aimee, please go ahead.
No, go ahead. I'd say you were leading into it. I was just going to say it does bring up an interesting topic around the importance of the regulatory environment in which you are establishing your data operations. So, but please comment.
Yeah, I suppose with Gerald, what I would say is this issue crops up every now and again, and you see it not just in Europe, you see it in Australia. There was a conversation on it, came up in the UK a couple of years ago. So I suppose there is a status quo, which is there are no backdoors. The issue is whether there's enough head of steam that builds up to overturn the status quo. And I think you will certainly have the privacy activists on saying, personal data protections, fundamental human right, therefore not to allow that. And, if you want to give some sense that if they're going to advise end-to-end encryption as a way of ensuring that there isn't surveillance from, say, US authorities, then putting in backdoors isn't going to make much sense there. So, there isn't a logic there. What I was going to say, Aimee, was just in terms of, picking up on some of the practicalities of this. If you're a US business, what can you expect will happen? And maybe it's happened already since July when the court decision came out. And it'll depend whether you're a B2C or a B2B, but let's take a B2B company. So let's say you're a US company and you're doing business with Europeans. And what you may have seen and what you're going to continue to see now is that the EU data exporter will have to work with you as the data importer to really understand the lawful, the legislative landscape in the US, but also as a company, and Chris touched on this, are you typically subject to FISA 702? Are you typically subject to, Executive Order 1233? How often do you actually get requests? And so are you the type of company that's going to have, have the bullseye on your back, so to speak, or not, as the case may be? And you will be asked a lot of questions from your EU counterpart to that effect, but also as regards your entire schema. Where is the data residing? Where is it going to? Who are your sub-processors and their sub-processors? And where all the onward transfers are going? You're going to find that that's going to become more important, and you're going to be asked to help the data exporter. And particularly if you're looking at onward transfers, you're going to have to do transfer impact assessments down the line. So if you have an Indian call center, what's going on there? Are they accessing personal data of European citizens? And if so, what do the laws of India say around that? So So there's quite a web here when you actually dig into it. And you're going to be asked to give a level of reassurance to the data controller in Europe about what's going on within your chain. And you need to be able to answer these questions because as a vendor, your business sort of relies that you will be able to keep to the standard contractual clauses. And you know, I think it's not unrealistic to say many people sign standard contractual clauses without ever having read them. And you just sign them and you may not even be aware. You may need to actually get them down and read them, and remember they're going to be replaced. So one of the things we mentioned earlier on was busy week last week for privacy pros, because the European Commission also came out with the long-awaited update to the standard contractual clauses. And not only were they, you know, controller to controller, controller to processor clauses, but they issued them in a modular way so that they also cover processor to controller and also processors as well outside of the EU. And these are going to replace the standard contractual clauses. And there is a link in these new standard contractual clauses to Schrems. So they obviously waited for the European Data Protection Board to come out with their guidance, but there is references to the Schrems court case and decision of the court in the standard contractual clauses. So I think more than ever, there's going to be a real need to, maybe for the first time, actually understand when you sign up as a data processor to a standard contractual clause, what is it that's in there, and make sure that you understand what you're agreeing to, because in there it talks about, are there certain laws in place that might prevent you from actually keeping your side of what's in the standard contractual clauses. So it is a complex web, but if you're in the US and you're dealing with EU exporters whereby they're sending you personal data, maybe you're processing it, maybe you're in marketing, maybe you're in CRM, maybe you're in doing various different things with the data, you will need to understand the implications of this for your business.
Some really good insights and advice there. Is there any questions coming through on the chat, Sarah? Just again, keeping an eye out on time.
Yes, I do. I do have one. And I don't know. Oh my gosh. Let me just pull it up here. Okay, so I'm sorry. I don't know why my is having a hard time here. Give me one.
While you're looking at
1 second. So you guys chat while I try to get this.
I just have a comment, and that's just something in case folks are thinking about this. You know, one of the you know, again, talking about U.S. surveillance law, right? So you can't contract around U.S. surveillance law, and unless you are thinking about technical measures, some of which are suggested in the guidance, it's very difficult to circumnavigate that. So one of the questions is that clients have as well is there any chance that there's going to be a renegotiation of something like the Privacy Shield? And my view of that is that it really depends on whether there can be any kind of amendment to U.S. surveillance laws. A lot of whatever privacy is going to look like over the next 2 years, the potential for any momentum in this space is really going to depend, frankly, on what happens on January 5th in the runoff elections in Georgia. Because I think the world is going to look different if Democrats have control of Congress as well as the White House versus if there's divided government. If there's divided government, my own view is that we're really not going to get very far on any of this. But if it's unified government, there's a possibility of some movement. So just something to think about as a contingency here. But otherwise, I think the status quo with more information coming out of the EU is going to be where we are.
Okay, thank you, Chris. And sorry about that technical difficulty. So I do have, it's a two-part question. There's a few questions within it though. So give me just a moment. What practical responses have you seen companies take since July? Have their data transfer practices changed? What practical responses have you seen? Oh, wait, sorry, there's a repeat. And then how does this play out in terms of Brexit?
The Brexit question.
Let me really quickly tell you what I've seen on the U.S. side, and then I'll let Aoife answer the Brexit question. So on the U.S. side, interestingly, what I've gotten is a lot of for anybody that's Privacy Shield certified, it's all right, so now what do I do? And it's usually, you know, some combination of standard contractual clauses and consent, depending on the organization, with the understanding that there's risk. You know, a lot of it is also, I've seen a lot of, you know, to Aoife's point, and I think it's incredibly important, a lot of sort of auditing of privacy practices and security practices, which is absolutely crucial. And I've been recommending that, and clients have been doing that to understand better sort of where their risks are. So that, I think, has been a very useful thing to come out of this, because, you know, all sorts of risks get identified when we do that, that have nothing to do with transfer, that are well, in some ways they have something to do with transfer. But that's mostly what I've seen. But beyond that, I've also seen a lot of argument that from large companies that it was just Privacy Shield that was invalidated. We don't have to worry about this because standard contractual clauses are still valid, and that could be a very difficult conversation to have. So that's what I've seen on the US side.
Yeah, I think from the European side, and it's probably not dissimilar, was when the judgment came out, you know, there was a sense of, okay, let's do our fact finding. Let's go back. If we have records of processing, let's see, did we capture all our data transfers in there? If not, let's augment it. But really, let's do a deep dive and make sure we know what data we're sending where, to whom, and what's the onward transfer. So really kind of get that snapshot. If it was Privacy Shield, then okay, it's invalid. We got to do something. The fallback is going to be standard contractual clauses. And then I'll say most people sat and said, okay, I'm adopting a wait and see, because, you know, until you know, they're waiting for this European Data Protection Board guidance to come out, because people were not going to instigate big scale changes. I wouldn't want to be the person in the company saying, let's overhaul everything until we had a bit more clarity. Now that that clarity has come, I'm not sure what people are going to do, because frankly, where it gave examples of use case 5 and 6, which is the SaaS model, where you need to transfer data in the clear for use in an importing country in the clear, it says there are no technical measures there that would sufficiently ensure the essential equivalence. So, you know, if you took that literally, you'd be saying, okay, if I examine the US and the court has said that with FISA and Executive Order 1233, there are questions, and I can't make it whole by a technical measure, would that mean I need to cease and stop and actually make sure there are no transfers in the clear going? And I haven't seen anybody stopping it. So that for me is the interesting one, to see what happens there, because business has to continue. People have to, you know, data transfers are part of the world we live in at the moment. So that's going to be a really interesting one to watch. I think for things like analytics, I think a lot of companies will look to see, can they pseudonymize the data? And to Gerald's point, look at end-to-end encryption. But then to a certain extent, the European Data Protection Board said, you should be doing this anyway, because privacy by design, privacy by default, data minimization and accountability actually require you to do this anyway, which was, you know, they didn't shy away from saying that in their recommendation. So it is interesting. There was a wait and see approach before anybody did anything too drastic, but now that it's come out, I would imagine there's a lot more analysis going on and sort of sectioning off the data into different categories of risk, to Chris's point, the type of data, the countries, and what's essential for the business. So it's going to be interesting to see what happens here.
Yeah, I think it's like from our perspective, I can reflect that obviously it's like it does require careful analysis, and any kind of rash action would seem not too prudent either in July or August or now. I think what we can say is that we have updated things like privacy policies. We have clarified certain things. I think creating the right level of transparency for both the regulators as well as the customers and end users needs to be part of that. Because just looking at what we have done in the past, what we're doing today, and what we're planning on doing in the future, we're aligning in many ways with those kind of principles around anonymization, around pseudonymization where it's appropriate, and encryption across the board, including zero-knowledge encryption, where we don't have the keys for critical data that our customers have. But at the same time, communicating that even to sophisticated regulators or sophisticated large multinational enterprises is always a challenge. it is not, we live in our own world. We try to see and we try to make this as clear as possible. But we have seen literally this year in discussions with various regulators that some of the information that we're trying to put out about our practices are not do not necessarily have the right amount of clarity. So I think that creating that clarity, creating legal language that is not the stereotypical 3-point font that you need about half a year to read through and fully understand, but make it clear, much more clearer terms that are more easily accessible, needs to be part of that strategy as well. And I think that is something where all companies can actually work on today. I would always call that as a call to actions, like make the kind of information you have available really accessible to everyone who needs it. And then going forward, obviously adjust as needed as well.
So we do have a couple more questions, but I think as we're getting to time, I was just going to suggest that I'm going to ask the panelists offline, and then I'll include them in my write-up back to the audience.
Great, thanks. I was going to say, yeah, we've just come up to the hour mark, so I think we could probably revisit this conversation in another couple of months' time to see how it's evolving and kind of steps companies are taking, how they've taken on board some more of the guidance that's come in and some of the measures, or if new technology solutions have been emerging. I think it's just left to kind of say a huge thank you. That has been a wealth of knowledge, of information sharing from all three of you, and thank you for your time. And we'll leave it over to you, Sarah, to follow up.
Excellent. And again, thank you to all of you attending today. Thank you to Aimee, Jerry, Chris, Aoife, of course, IDA Ireland for sponsoring this program, and for our security community sponsors, Nuance, Sonatype, and Vectra. Thank you all. Have a great day. And yes, I am sure we will be revisiting this. I know Chris and I usually do this about every 6 months or so. So lot to talk about. And again, for all of you, I will do a follow-up and I'll just ask these quick questions offline and try to get an answer for you. Thank you. Have a great day, everybody.
Thank you.
Bye-bye.
Thanks, everybody.